From the Family Support Expo in Toronto, Canada, this is The Smart Divorce on Divorce Source Radio. I'm Steve Peck, and here's the host, Deborah Moskovich. How are you, Debbie? Whoa, I didn't turn your mic on. Sorry about that. It's not the first time I've done that. How are you?
I just love that intro music. It makes me happy. Wants to get up and dance.
Really?
Yeah, like it's fabulous. And it puts me in such a great spirits to interview our guests.
Well, maybe we need to think about revamping yours, maybe. You know, we've used yours for a couple of years now. Actually, you've been on 2 music changes. You're on your second.
Have I really?
Yeah. The first one I selected, I didn't think was so great.
But what I like about this, and even just going through divorce and being so emotionally distraught, that the music you listen to changes the frame of mind you're in.
It really does.
I know that there's times where I've been feeling really low, and then I would listen to Vanya or something, right? And someone says, what are you listening to? Oh, okay, I can tell what your mood is. But as soon as I change it to something that's got a great beat and uplifting,
right,
any sort of sadness I feel is slowly goes away.
On the other hand, if you're going through divorce or separation and you're listening to like country music, come on. You could drive your car off a bridge.
Oh, yeah, you got to check out what the lyrics
are. My wife left me, my dog died, and you're oh my God.
Yeah, it makes you want to drink.
Well, listen, we've got a great guest on your show. I did a show with him earlier, and you two are going to talk about ADR.
I love
ways.
that. Alternative dispute resolution. All too often, I think, John, and correct me if I'm incorrect, but people think that litigation is the only option. And I think that there needs to be more education in terms of what the options are. I mean, really, at the end of the day, how many couples really go through a full-blown trial? Less than 5%. I think it's 3% now. And do people think that they're going to go to court and litigate and have all their dirty laundry aired out, and all of a sudden, I'm going to be the right one and you're going to be the wrong one? That was exactly what happens.
This is John Schuman, by the way, attorney. We didn't really introduce him.
Oh, I'm sorry, John Schuman of Deborah Smith and Frank.
That's true. Even now in some of the other communities, I run into people who think the way you tell your spouse that the marriage is over is by serving them with a divorce application, and you're in court, and that's probably the worst way to resolve the matters between you. I mean, sometimes it's necessary to go to court, but if you want to keep your stress down and keep things at all good between you and your soon-to-be former spouse, that's not the way to do it.
Yeah, I mean, as soon as you said that, I thought to myself, we talked about music earlier, da-da-da-dum. That's a really dumb thing to do. And especially we were talking about, too, John and I were on a panel earlier this morning talking about all sorts of different issues related to divorce, and one of the things that people did, which I know that was a bad thing, is in the old days, lawyers would just drop off the separation agreement and say, this is our done deal, take her to leave it. And not a good thing to do. You've got to give people options.
No, that sets off some people still do that, but it gets the lawyers back up right away if they see that that's the position you're taking. We're doing this and you don't have a say in it. So
how do you start off, not that on a more amicable note? What would you suggest rather than litigation? Well,
when I first see clients, and sometimes I see them right after, sometimes I see them before they actually separate and they want to know, I tell them that litigation is not the only option. It's probably not the best option in most circumstances. There are a number of things you can do that'll keep things better between you and your spouse, and there's a continuum of how much you're going to fight and how big the fight's going to be. You can work it out on the kitchen table sometimes if the issues aren't complex, and go through mediation or arbitration or collaborative process, which is all in the middle. And if you're going to end up in court, you're in a fight and you're not going to like the results, because even if you win, I mean, judges will always say nobody wins, and judges don't like having one side win, and you're going to have a stranger impose something on you with so little input from you. I mean, the judge is going to sit up there and he's going to hear what your lawyer says for half an hour and what the other lawyer says for half an hour, and then they're going to formulate something based on that, not based on what you would want. And that judge has no idea what your family values are or what you want to see your kids do with their lives.
the judge only knows what he or she is reading in the affidavits. Now, if you have a great lawyer who is a skilled litigator, you might have a really wonderfully drafted affidavit. But if you don't have such a good lawyer, that is a serious undoing, because if they don't know how to go to court and litigate, and you've got a poorly worded affidavit, that's your undoing.
That's right. You have to have, I've had judges compliment me on how much they love my affidavits and how they sound like stories and they enjoy reading them, which I find is good. But they go through and they make a decision at the end, and oops, they left out that, little Sally has swimming on Tuesday nights and now she can't go because the judge didn't know about that and I didn't know about it. And the parents said, well, that was important, but we all forgot. And because it's that conversation, you've got one chance to pitch it to the judge, and the judge makes up the decision based on what they said. They don't have that same dialogue and the same knowledge of your family that you have in other choices.
And not only that, like when you talk about the judge who's making the decision, this third party who is a stranger, the courts are so backlogged with cases that sometimes they don't even have a chance to read your file until you're appearing before them. So if litigation isn't the way to go, what else do you think? Like arbitration. Now, there is some confusion about the differences between litigation and arbitration because you've got a third party making the decision for you. I actually recommend to a lot of my clients that if they have to litigate, if they have to have a third party make that decision for them, sometimes I feel that arbitration is the way to go. Do you want to talk a little bit about arbitration?
Yeah. Arbitration is as you said, has a third person make the decision, and you pick the arbitrator.
That is so much better.
It is better.
Because you know that you're getting someone who's skilled in family law.
That's right. You're getting somebody who, depending on where you are, you may get a specialist family law judge who knows something about family law, or you may get someone who has never seen a family law case before in their life, has no idea about family dynamics. They may have practiced criminal law or may have practiced corporate securities throughout their career before they're appointed as a bench, and then sat on the commercial list for their entire judicial career until they heard your family law trial, and they have no idea what's going on in family law. But with arbitration, you can pick the person who's going to make the decision. So you pick someone because they know that something about family law, and you respect what they have to say about family law, and they can also share some of your values. That They have some, you want your children raised a certain way, and you and your soon-to-be former spouse can pick somebody and think, yeah, that's someone else we think would also want their child raised in the same way, or we'll at least listen to how we want to have our child raised. But,
bottom line is litigation or arbitration or adversarial. So let's look at the more amicable dispute resolutions too.
Well, arbitration is, before you get there, has another big advantage. And recently in an appeal case in Ontario, the judge said, you can pick any process you want for family arbitration as long as you agree on it. So you don't have to have a witness box cross-examination type arbitration. You can pick out any other process that you want as long as it's basically fair, and have it resolved that way. So you can have a talk with the arbitrator, with both parties talking to the arbitrator. You can have them decide discrete issues. You can have them take a entirely different approach that is less adversarial than the court process if you want.
So then it can be as formal or informal as the couple agrees to.
That's right. As long as they agree to it, it can be as informal as you want. And that appeal was actually on a very informal process that was designed to make the process short and resolve quickly and keep the fight to a minimum, and the court upheld it.
That's amazing. And you know what, I like that the fact about arbitration is that when you say that you're going to be in to see the judge, the third party, at 9 o'clock in the morning, you're seeing them at 9 o'clock in the morning, rather than waiting around in court for another 4 hours before you might get in to see somebody. Yeah. And you're paying your lawyer for that amount of time.
Yeah, that's what people say. They say, but it's going to cost me so much more because I have to pay the arbitrator too. I have to pay you as my lawyer, and I have to pay the arbitrator as well. And I say, no. If you go to court, you're going to pay for me at my hourly rate to sit around in court to wait for a judge to hear me, and when the judge is available.
Right.
And you may have to take the day off work so you can do that court appearance. If you pick an arbitrator, a lot of the stuff that we go to court for to work out simple disclosure issues or procedural matters, the arbitrator works out by picking up the phone and calling both lawyers, and it gets done in like 10, 15 minutes instead of waiting for 4 or 5 hours at court. Makes it a lot cheaper and a lot less stressful.
So talking about, being cheaper and less stressful, when you go to court, there's many procedures you have to go through or processes you have to go through before you get to a full-blown trial. case conference, management trial, all of these different things. When you arbitrate, you're strictly going to that third party to provide your case, right?
That's right.
So you don't have to go through all these little steps before you get to the big one.
That's right. You can skip all the steps to go straight to an arbitration, or you can select the steps you want to do. I had a case where it was just supposed to be arbitration, and the parties were just supposed to have the issue decided, and we actually, in talking to the parties, we actually started off with what we called a trial or an arbitration management conference with the arbitrator. And it wasn't really, it was more of a mediation/arbitration thing, where in that first stage, the arbitrator tried to see if he could help the parties reach a resolution without going to the arbitration phase.
Which is great.
That's right. And in that process, with mediation arbitration, you have that choice. Judges don't have a choice, the procedure they follow.
No, but sometimes, yes, that's right. So sometimes judges will send you out into the hall and say, you know what, let's see if you can figure this out on your own. So in essence, you're kind of mediating with your lawyers, right? So for our listeners, we've got listeners from all around the world, which is, really wonderful. So if you can just explain to our listeners what the procedure is in general terms for going to court. Like, you're not getting the full-blown trial. You could have a case conference. What are the procedures that you have to go through before you even get in there for your full-blown trial?
Well, in every jurisdiction, the first step is that you have to file a pleading, whether it's a statement of claim or a divorce petition, or in Ontario it's an application for divorce, which is a formal court document where you set out what you want the judge to order and why you're entitled to it. That is usually not a friendly document, because you're saying you want the court to order something against your spouse, and here's the reasons why, because often it comes across as you don't think they're a very nice person. Accompanied with that, you have to do in just about every jurisdiction, as long as you're asking for financial relief, you have to file something called a financial statement, which gives in detail what you're earning, what your assets are, what your debts are. It's from a lawyer who does a lot of litigation, it's an easy thing to cross-examine on, because if you fill out something that's not right, you can clearly make someone look like they're lying. And so you have to fill it out very carefully and very accurately.
But people have to do that anyhow, right? Whether or not you litigate or mediate.
That's true. Everyone has to file a financial statement, but the difficulty is when you go to court, that financial statement goes into court, and it's then a public record. So your next door neighbor can go and see, well, I wonder what they made last year, and they can go and look. And I have actually had cases resolved on the basis that, people who have been a little iffy with their taxes, our Canada Revenue Agency occasionally goes through and looks at people's financial statements and what goes in court to see if they've been truthful on their taxes, or if there's something they need to check out a bit more.
So you don't really want if you really don't want a public record, you don't want to litigate.
No, that's the big advantage of any ADRs. It can be private, and no one has to know what the issues are.
Yeah.
Even if it's not just the financial statements, but if you're having a nasty custody fight and you say something that's not nice about your spouse, or your spouse says something not nice about you, any of your neighbors, anyone who knows about that your divorce can go down to the court office and ask to see your file and read it.
It's funny that you say that. I know a lawyer, who told me that when his divorce was finalized and he started dating again, part of his due diligence through dating went to the courthouse to see what the file was from the person that he was interested in dating. And I thought that was really interesting, because he said he could learn a lot about the people he was considering getting involved with based on the affidavits.
Yeah, and absolutely. When I do marriage contract where someone on their I'm saying I'm marrying this person, he's been divorced twice before, I often say to them, you want us to go look at the divorce file from the last time so you can see what type of person you're marrying and what this could look like if you're going to divorce next time.
That's brilliant. Really, that's brilliant.
But of course, it's a bit like the internet. That divorce file can stick around forever, and people can go back and look for it. And the worst scenario would be that your kids decide at some point when they were adults, they wonder what really happened between mom and dad, and then they want to go to the court and ask to see the file.
Well, that's scary. You know what? Like, certain things you just don't want your kids to know.
No.
Okay, so you filed the affidavits and the financial statements, and then what?
After that, most jurisdictions have this thing called a case conference or some and that's supposed to be the first step. It's not always the first step, but it's a step where you meet with the judge to work out procedural issues, and it's supposed to be less formal. The judge is supposed to help mediate issues between the parties to avoid some of the more costly alternatives, motions and things. The judges on a case conference, the first step is usually geared towards, sorting out, making sure the disclosure's done, making sure there's temporary arrangements in place for the children, that people are safe between now and the end of the proceeding.
Yeah.
But it is a less formal step. Some judges actually do them in chambers and have a sort of a talk around the table. Others do it in open court, but it's no matter where it is, it's supposed to be off the record.
But that's a good thing, right? Because you're hoping that at that point the couple will settle.
That's right. A lot of cases do settle. If there's not a lot, they settle at that. There's not a lot of bad issues between them, then they do settle at the case conference stage. And if you get a good family law judge, often they will get a lot of things done at those case conferences, provided they have time. I mean, there's a lot of jurisdictions where, and I remember talking to a judge to tell me he had one day 40 case conferences on his list, which means he had about 10 minutes for each set of parents coming in, which means he wasn't going to get a lot of that into each family's circumstances.
Right, but the families don't necessarily have a chance to speak to the judges themselves if they have their lawyers with them, right? How often do the lawyers go for the case conference along with their clients?
Well, if they're represented, the lawyers go with the case conferences.
So you're not the one specifically speaking, you being the client. I just want people to know that, it's not you talking to the judge, you're talking through the lawyer.
That's
who could
right.
Probably better speak on your behalf, right? Because they know exactly what the judge needs to hear.
That's right. We actually, as lawyers, one of the best things we offer is we know the judges, people who are making up the decision.
Yeah.
So we know what the judge wants to hear to like you. And often people, when they go the first time before a judge, they're terrified. And this is their first time, for most people, in a courthouse at all. And it's their first time having any contact with the legal system. And all of a sudden, they're in a room with a judge, and most of them are fairly nice, but still, they're the person who's wearing the robes or wearing a suit and is obviously the person who's in control. And it can be scary.
It could be very scary, which, for our listeners who feel that there is no other option other than litigation, you want someone like John by your side who understands the system. I mean, I wouldn't put all my money on a lawyer who's never been to court before. This is not the time to be learning about the process.
No, and
so don't go with the cheapest lawyer just because. You need to go with the lawyer that's got the most experience when you go to court. Yeah,
we've taken over a number of cases, our firm, and we think of how much better this person could have done if they'd had someone who knew what they were doing right from the beginning. Yeah. And it's not even necessarily that we're sharks or vipers or however you want to refer to us. It's that we know how to get the case settled. There are certain lawyers we know who aren't very good, and we know that because they're on the file, it's not going to settle. It's going to go to trial, and the parties going to spend too much money getting their case resolved because they just don't have the grasp of how to settle things, how to deal with things reasonably, or don't know the law well enough to apply it to their client's situation.
So that's really frustrating for the family, because here you have a client that's reasonable. The party on the other side is not. So even if you are trying to cut down on your expenses by being reasonable, you're providing all the disclosure, you have no control over what the other side is doing. And I think that's so important for people to understand, is that once you go down that path of litigation, it's a slippery slope. You can't put the brakes on and say, sorry, I don't want to litigate anymore, because if the other party is well into it and wants to do that, you can't get off that ride.
No, it's court's the only process that you can force someone into, and you can keep them in, and it's probably the least friendly option for resolving your matters, but it's the only one where you can compel someone to be there. And once you're in there, you're always able to get out again and go to arbitration or mediation and resolve your things out of court, but both parties have to agree to do that.
Okay, and what's next after the case conference?
So after the case conference, if you've got a really contentious matter, there's a couple things that can happen then. There's these things called motions, which are appearances before a judge to decide temporary matters until trial. And those are done on the basis of affidavits. They are done in some of the U.S. states by way of actual standing in the witness box and giving oral evidence, but for the most part, they're done on the basis of affidavits and lawyers' written arguments, with the lawyers giving a short pitch to the judge about what the appropriate result would be. And again, if you're in a motion, you don't, as a separated spouse, you don't get to necessarily tell your story live in court. You get it told through an affidavit. And
which can be really hard for a lot of people, right? Because if the emotion doesn't come through, and the emotion shouldn't come through. So, like, for someone that's litigating and thinking, oh, like, it doesn't sound so bad, it's horrible. Having been through myself, it's you're reading stuff that you feel is not true. So, how can the person that you might have had, children with, be saying these things, or the person that you loved, be saying these things? It's tough. So, from an emotional perspective, I want our listeners to be aware how difficult litigation is from the emotional perspective.
Yeah, it's terrible.
It's horrible. It's just it takes over your life.
And the things that are said in affidavits are often awful. And even when we're doing simple matters and we try to keep things as even toned for the court as possible without getting into anything, sometimes we unintentionally push someone else's buttons, or our client tells us to put something in knowing it's going to push their spouse's buttons, and no one knows it, and it just makes people furious when they read what's in affidavits.
And you can't take those words back. I mean, they're in black and white, right there on the paper. Okay,
in the court file forever.
Yeah. So we've covered litigation, we've covered arbitration. So let's talk a little bit about our mediation. I don't know if you do collaborative law. We talked a lot about collaborative before, in other shows. And four-way, actually, I have a question. Why would I need to mediate if I could do a four-way meeting with my lawyer? My lawyer and the lawyer on the other side, and my soon-to-be ex-partner.
That's a good question, because it often makes sense. Why, if we've got all these professionals, can't they work things out?
Yeah.
And everyone knows what they're doing, everyone knows the law is. Why can't they work things out? And why is mediation so successful in doing this, even when the lawyers are there too? Why do they need a sort of a fifth person there? And, it's the same question. Why do we have mediators in labor disputes? Because they know what's going on, too, and they know what they want. And, every other type of dispute, why do mediators help? And part of the reason that mediators help is because, well, there's a few reasons. One is that your lawyer you've hired you've told them your side of the story, and you've told them what you want them to say and how they want to present your case. And so they're doing that, and they've only heard your perspective. It's rare for a family lawyer to hear the other spouse's side.
Yeah.
But a mediator gets to do that. A mediator gets to hear both sides and get their picture. And sometimes the mediator can come up with new solutions that make sense, but because neither side has actually heard each other well. And one of the best things mediators can do is be good listeners. And once they've heard listeners say, well, why wouldn't this work? And often the parties, the lawyers say, oh yeah, why didn't we think of that before? It's because they hadn't heard both sides.
Yeah, I like that. I like that very much. And I think the importance of mediation is critical for people to understand.
Yeah.
Another.
Yeah,
go ahead.
I would say another important part of, or advantage of mediation is if you're in, your spouse is, or if I'm representing you, your spouse is not going to trust me. Maybe in collaborative process they were, but they think that you're the person who's taken your side. They're not taking my side, and my client's going to feel the same way about the lawyer on their side. The other lawyer and I may get along really well. We may be good friends, but no matter what we say, my client's not going to believe that other lawyer, anything they say in the meeting. But a mediator, especially one who's experienced, what they say is impartial and is something that both sides can believe and trust, and that often really helps get people to a resolution.
And lastly, just quickly, collaborative law?
Collaborative law is a good process for people who really want to work together. I refer to it as more of a brainstorming session rather than a traditional mediation. You sit down with your lawyer and your spouse's lawyer, and instead of doing the usual buy a car type mediation, you do let's throw things up on the whiteboard, let's think of every possible alternative, and let's think about what works best and what doesn't work best.
Yeah.
And it's an entirely different way of dealing with matters.
Different mindset, isn't it? And it's different mindset as a lawyer.
That's right. And it can be hard to wrap your head around when you're dealing with it, but it's sort of putting the whole family best interest into, or considering the whole family's best interest rather than just your clients, and facilitating discussion and letting the clients do the discussion rather than the lawyers geared to doing it, which is what happens just about every other process. The lawyers run the discussion.
So what do you think, parting thoughts? What are 3 lessons that you want your clients to come away with, or people that are going to call you for a consult? What should they really think about going through divorce?
Well, they should think about really how much they want to fight and whether the fight's worth it. So that's number one, because fighting with your spouse is going to have long-term negative repercussions for you, your spouse, your children, sometimes the people you know.
Yeah.
And that's, do you really need to have a fight? Or would it be better just to work things out on a more amicable basis? And it almost always is. As long if your spouse has got mental health issues or substance abuse
Totally
issues,
different.
may not be possible, but in every other situation, it's almost always better to work things out with them. And this, which comes to the second point, is if you use an alternative dispute resolution, no matter what it is, you're going to have more input into what the decision is. Even if you're in arbitration, you have input into what who the arbitrator is and how they're going to make the decision, and you can tell the arbitrator what you want them to consider. Yeah. So you can have a solution that's better geared towards your family and takes into account what you think is important.
That's fabulous. That's really what you want, right?
Yes.
So that you're part of the process, not having somebody make the decision for you. And
Yep.
last point?
And the last point is, I guess, it's part of my thing, is when you're going through it, I think you need to give a serious consideration to, and sometimes this takes a bit of stepping back and reflecting, which process would best protect your kids or best work out for your children. Because if they have to be protected with using the force of the law, then it's going to be the court.
Right.
But that's almost never the case. Chances are you want a situation that'll get their needs, their desires, what they actually, their most basic needs taken into account. And any process does that better than court, where the judge doesn't really ever get to get a good idea.
And really what we want to do is put the children's best interest first. I mean, that's first and foremost what any family should do. So, John, if anybody wants to get in touch with you, what should they do?
They can check out my website, which is www.devry.ca. My phone number is 416-446-5847, or you can email me, john.schuman, SCHUMAN, @devrylaw.ca.
Fabulous.
And Deb, John and I did a show on children too, which is awesome. So for the listeners, they can find that in the archive. A great show we did earlier today.
That's amazing. I think that's so wonderful. John, you offer us so much wise advice. Thank you.
Okay. Thank you very much for having me.
There you have it. Another great episode of The Smart Divorce with Deborah Moskovich. Deb, it's been a pleasure seeing you live and in person. It's better than that little TV screen we have.
Oh, it's so hard sometimes. We don't even see each other. It pops in and out. So I think this is really wonderful, that face-to-face, one-on-one, in the flesh.
Oh, I've seen Deb, ladies and gentlemen, in all different kinds of, I'll get her on Skype and she'll be, I don't let just anyone see me this way.
Just straight from the gym or whatever it is.
But, we're old pals.
Yeah.
It was great to see you in person. Thank you, Deborah. We'll talk to you again soon.
Absolutely. I've got a couple good ones coming up next.
Cool.